This Guy's Garage. Like and subscribe.
Ready to begin? Mr. Motz, I cut you off. I apologize. You now have the floor.
Very much, Chair. Being we have reconvened and nice seeing everyone again for this meeting, there has been significant developments since the last time we met, specifically with the Mosley decision. And so I'm prepared to move the following motion that was duly placed before the committee, that in light of the developments since the committee's most recent meeting, including a federal court ruling,
I apologize. I'm a new member of this committee, and I would wonder whether motions that are distributed and debated are by order of receipt. I believe my motion was sent in first, and as a new member, I have a question for you. That's a good question. Well, my reflex is to give the floor to who asked for it first, and you raised your hand after Mr. Motz. And to my knowledge, we have two motions. We are to study yours and Mr. Motz. Now, I have no, preference one or the other. Because Mr. Motz had his hand up, I gave him the floor. No problem. I just wanted clarification as a new member. Mr. Motz, point of order, Mr. Brook. After. All right.
Chair, and I'll just start that moving of this motion over. That in light of the developments since the committee's most recent meeting, including a federal court ruling, which found that the government's use of the Emergencies Act to have been illegal, and that the special criminal laws subsequently created by the Liberal cabinet to have been unconstitutional, to be an unconstitutional breach of Canadians' charter rights, as well as correspondence from the Privy Council office concerning translation of the evidence before the Public Order Emergency Commission. A, in relation to the federal court judgment, the committee invite the following witnesses to appear separately for at least 1 hour each. A, the Honourable David Lametti, the Minister of Justice and Attorney General of Canada at the time. B, the Honourable Arif Virani, the Minister of Justice and Attorney General of Canada. C, the Honourable Marco Mendicino, the Minister of Public Safety at the time. D, the Honourable Chrystia Freeland, the Deputy Prime Minister and Minister of Finance. E, Royal Canadian Mounted Police Superintendent Dennis Benoit. F, representatives of the Canadian Civil Liberties Association. G, representatives of the Canadian Constitutional Foundation. And H, other witnesses whose names are provided to the joint clerks by members of the committee within 10 days. And 2, an order to issue for all legal opinions which the government relied upon in determining that A, the threshold of threats to the security of Canada is defined by Section 2 of the Canadian Security Intelligence Act, required by Section 16 of the Emergencies Act, had been met. B, the thresholds required by paragraphs 3A or B of the Emergencies Act concerning a national emergency had been met. C, the situation could not be effectively dealt with under any other law in Canada, as required by Section 3 of the Emergencies Act. D, the emergency measures regulations were compliant with the Canadian Charter of Rights and Freedoms, including the analysis relied upon by the Minister of Justice in discharging his responsibilities under Section 4.1 of the Department of Justice Act. And E, the Emergency Economic Measures Order was compliant with the Canadian Charter of Rights and Freedoms, including the analysis relied upon by the Minister of Justice in discharging his responsibilities under Section 4.1 of the Department of Justice Act, provided that these documents shall be deposited with the joint clerks without redaction and in both official languages within 10 days of the adoption of this order. B, in relation to the translation of commission evidence, the committee invite the following witnesses to appear separately for at least 1 hour each. A, senior officials from the Privy Council office, and B, other witnesses representing parties which placed unilingual submissions before the commission or entities whose unilingual evidence was before the commission, whose names are provided to the joint clerks by members of the committee within 10 days, and 2, members of the committee shall, within 10 days, identify their preliminary lists of unilingual commission evidence or submissions for priority translation to the joint clerks who, in turn, shall relay those requests to the Privy Council office. C, to accommodate the scheduling of witnesses, the committee meet during the weeks of March 4 and 11, 2024, if necessary, and 2, if the number of witnesses proposed under clauses A, 1H, and B1B warrant, the joint chairs shall convene a meeting to discuss prioritizing their respective scheduling. And D, in relation to the committee's draft report, the committee suspend its work on the current draft report. The analysts be directed to prepare a second draft report incorporating the information and analysis set out in the federal court ruling, along with the evidence received under paragraphs A and B. 3, members of the committee may, after the committee has received evidence under paragraphs A and B, submit draft recommendations and conclusions for the draft report, including those which may have been negated by the committee on May 16th and June 6th, 2023, where reconsideration may be warranted in light of the federal court judgment or the evidence received. And 4, the committee work toward a goal of tabling its final report by June 21, 2024. So, Chair, this is a very comprehensive motion. It covers off a number of things, and I believe very succinctly identifies some of the areas where we want to go, or I think the committee needs to go in preparation for a fulsome study of and conclusion to this particular event of the invocation of the Emergencies Act. Now, if we look at the reason why we're here, and in following along with the purpose behind our committee, the Mosley decision is exactly some of the areas where we need to cover off. Was this legal? Did they follow the rules of law? Was it charter compliant? Those are all things that we need to examine as a committee. And just for everyone's reference, the federal court, I think, provided a very succinct review. I particularly was pleased with how well it was presented and provided clarity on not just he made a decision, but he provided the rationale for the decisions, and I think the way they were very, very sound. And then have a report done, and if there's dissenting reports, then those there's time to get those in as well. I certainly I'm open to debate on this, and I will acquiesce my time to the next speaker, Chair.
Based on the legislation that actually created this committee, Canadians are expecting us to submit that final report, and I believe we are there. I don't believe that we need to revisit having all of the same witnesses come back, based on the fact that a court has found with the Mosley decision something that the Conservatives were of course in support of. So I brought forward a compromise in terms of bringing a path forward and opening that conversation on how can we, between now, we have, I think, 12 meetings scheduled between now and June. How can the committee find a path forward in terms of addressing the question of translation and addressing the question of, okay, while outside of the scope of the mandate of this committee with respect to the Mosley decision, how do we get further explanation? And I think that's the will of the opposition to hear from the two ministers who are involved. And that is why I put a good faith motion forward. So I'm hopeful that we can come to some common ground here and move forward in a positive way so that we can issue that final report.
What we heard from the Prime Minister to Marco Mendicino and David Lametti and Minister Freeland and Minister Blair and probably the entire cabinet bench was this was necessary, this was lawful, and we had legal justification.
Charter compliant.
It was charter compliant. When we asked for evidence of charter compliance, oh, you can't have that. That's protected by cabinet confidentiality. Or you can't have that, Mr. Brock. That's protected by solicitor and client privilege. But the Prime Minister had no problems waiving privilege, had no problems waiving confidentiality with Justice Rouleau, save and except that legal opinion that they received from the Department of Justice, which would have laid out under what legal authority do you have as a Prime Minister and government to invoke that act. They would not share that even to Justice Rouleau. And I remember this exchange because I watched it live and I read the transcript after we heard the in-chief testimony of David Lametti, former Justice Minister, and the cross-examination, as judges often do and are entitled to do. They question the witnesses. And Justice Rouleau did that. And Justice Rouleau, I'm not quoting word for word here, but essentially said, well, you're not going to give us the legal opinion that justified your use of the Invocation Act. Am I to take from that, I'm just simply have to accept your opinion that it provided you with the legal authority? And David Lametti said, yes, take my opinion. He could be right, but he also could be wrong. And I think it's important that we have access to that legal opinion, which is why we set it out in the notice of motion. And I think long term, because ultimately the government has telegraphed, like literally within minutes, telegraphed an intention to appeal Justice Mosley's decision, a very senior justice appointed by a Liberal Prime Minister, I might add, a very senior justice of the federal court. Other significant decisions that we have heard that impact the lives of Canadians, well, we're going to take it under advisement. We're going to examine all the circumstances behind the decision and weigh our options before we consider an appeal or not to appeal. But not this. Literally a jackrabbit response. He got it wrong. We heard that from our new Justice Minister. He committed judicial errors. I'm sure at that point our Justice Minister didn't even read the full decision. It was a very lengthy decision. And I would be surprised if he had the time to read the decision in full before he quickly pronounced all the judicial errors that Justice Mosley made in his decision. But this again was parroted by the Deputy Prime Minister and many other ministers. There are justifiable legal errors that we can appeal. Now, I'm saying this because ultimately, if they hold true to their word and they will appeal this decision, ultimately the appellate court, wherever that may be, the Federal Court of Appeal, maybe ultimately the Supreme Court of Canada, is ultimately going to hear from Department of Justice lawyers as to what the legal advice they gave to justify the invocation of the act. It's eventually going to come out. If it's going to come out eventually in this promised appeal, then let us share this with parliamentarians, let us share this with committee members, let us share this with Canadians.
Put aside the processes that we put forward to kind of pretend as though we're wanting to move forward when we're ragging the puck, and get more ambitious about concluding this committee so that before we rise in the summer, we've made our contribution. Because I think we adopt this motion, you can guarantee that we'll be meeting until the end of this Parliament.
And now, Mr. Green, you have the floor.
say I've certainly benefited from taking the time to listen to everybody's arguments. As you know, throughout this process, I've been fairly consistent on taking principled positions that I think are consistent with our party, and as a party that supported the invocation of the Act on its face value based on public information that was readily available. And while respecting the summary that was put in terms of the context, it seems that we always miss the context that there was an armed action in Coots. One that I think that the average objective person would look at as a threat of terror, given its attempted targeting of police. And as somebody who has a long history of being critical of the police as an institution, in this particular case, I think it's incumbent on us to recognize the seriousness of that moment and what that could have meant across the country. Now, you'll also recall that throughout the 3 years, I've been fairly consistent in supporting demands for documents. I believe that the public has a right to know, to the best and fullest of its abilities, the same information the government side has had privy to that got to the rationale. And I would state, like right here on the record, that I think that through this process, the government has failed to articulate itself in a way that is consistent with the law as it's been explained to us by numerous experts. But I have to recall the frustration that I had prior to the revelation of the scope of untranslated documents, about us getting to a place that I think we were at 39 of 50 recommendations we had already voted on. Like, we were already there. And nowhere in Perrin Beatty's, who I thought was perhaps one of our most learned experts, nowhere did I hear him say it's our mandate to be a book report club for Rouleau or any other judicial proceeding. That was not in the spirit nor in the language of any testimony that I've heard, and I think we've fallen into that trap. I think that the issue of translation is a serious issue, and I commend the senator for taking it through its obvious complaint and appeal processes as it relates to the commissioners and the Privy Council. But I would agree with Senator Harder that there is a translated version of the Rouleau Commission. And I can tell you, that I don't have the resources to sift through tens of thousands of documents. I don't think any of us do. And so at this point, I'm willing to accept translated documents as legislated through our Official Languages Act, and I'm ready to move forward. Now, I also want to honor the spirit of the search for documents and the search for particularly what are the threats to security and what's the threshold. I think that is a material issue that has to be addressed by this committee in order for us to have adequate recommendations that would hopefully modernize this act to contemplate the current social, economic, and political context that we're in that certainly wasn't contemplated back when Perrin Beatty drafted this piece of legislation. And so what I would put to this committee as a way of trying to find that common ground is I do believe that Ms. Romanato, MP Romanato, don't sell yourself short in your short time here. This is a good motion that you've put forward. I think that there is concessions there in terms of the witnesses. Because, let's be clear, we're offering a revisiting of witnesses in a way that we didn't consider during Rouleau. And if we're going to really open all this back up, then let's hear from the folks who were held captive in the nation's capital here, the residents and all the other people who testified at Rouleau. I don't think that makes sense for Rouleau, and I don't think it makes necessarily sense for this report either. But what does make sense to me, and I would put this to the movers of the motion, is if we break this up section by section, I'll tell you right now in this open session that Section A, subsection 2, which is your demand for documents, I support that. I've always supported that. And I think Canadians do have a right to know what were the legal thresholds the government was using to make this decision. I think that's material to our report, and I think that it would help dovetail. into the work that we've already done, the 39 or so recommendations. I'm prepared to pick up where we left off, and I'm prepared to accept the Mosley decision as an appendix to this, as we did with the Rouleau in its translated version, and I commend MP Romanato and the Liberal side for agreeing to revisit the other folks. I know this, having worked on this for 3 years. Minister Virani is going to be a very learned member as both a participant of this committee and the new minister. And I think that these are the folks that are ultimately accountable under their new ministerial mandates. MP LeBlanc, I think that's great. But what I'm not interested in is kind of opening this back up. And I've expressed that both offline, and I'm going to say it in open public now. And for those that are watching, before you get your fundraising emails, this is not a cover-up. This is a 3-year process that needs to come to an end based on a mandate that we have as a committee, without any conspiracies. There's lots of time for folks to get their say in these upcoming appeals and civil proceedings. And I would just ask that we do find that common ground, that we break this motion up. That would allow me to support the demand for documents. And then as it relates to section B, I think that subsection B and MP Romanato's motions are similar enough that I would be prepared to support MP Romanato's motion should it come to the floor next, after having supported the demand for documents. Those are my only comments that I'm probably going to have today. Thank you.
Did the government act within their legislative powers to do what they did? And so I appreciate we might disagree, and that's okay. And I again, I appreciate the comments that have gone on. I too don't want to sit here for years to come, and I think we can get this done expeditiously. I believe the Canadian public, who we are here to serve, deserves to know what it is that we are doing, why we're doing it, and that obviously there will be more than one version of a report. I'm confident of that. And so I guess the question needs to be asked, how long do we beat our heads against the wall to try and get a report that we can almost all agree to? And when do we say, this particular report does not align with what I believe the Canadian public deserves, and you present your own. So I think that's just something that I wanted the new committee members to be aware. I think we're going to be having bells here very, very soon, from what I'm hearing. And I do respect Mr. Green and your suggestion that there may be some compromises, as we all said at the very front end. We need to look at what those might be. And if everybody's in agreement while we vote, or whatever that looks like, we can maybe suspend for a little while and see how we might be able to come to some compromise.
So let's reconvene.
We have the dilatory motion on the floor. I understand Ms. Romanato wishes to withdraw that motion, so that we can deal with the amendments on my motion.
OK, so si tout le monde est d'accord, moi, ça me va.
If everyone's in agreement, that's all right with me. Go ahead, Ms. Romanato. Thank you. Indeed. With unanimous consent of the committee, I would like to withdraw my dilatory motion. Thank you, Ms. Romanato, and I apologize for having complicated things for nothing.
I wish to move an oral motion amending our previous motion as read out by my colleague, Mr. Motz. Amended motion to read as follows. After the word "that" in the preamble, all of the remaining language in that preamble to be deleted. So it'll read "that" in relation to sub A, in relation to the federal court judgment, sub Roman numeral 1, the committee invite the following witnesses to appear for at least 90 minutes, deleting sub A, keeping sub B, deleting sub C, deleting sub D, deleting sub E, F, G, and H, and leaving adding sub I.
You keep F, G, and H?
No, delete. Delete.
Okay.
Deleting C through H, Mr. Chair,
Okay.
and inserting sub I, the Honorable Dominic LeBlanc, Minister of Public Safety. Roman numeral 2 remains unchanged. Sub B remains unchanged with the exception of the full deletion of paragraph B. So sub B, sub Roman numeral 1, sub B to be completely deleted, and then an additional sub C to read officials from the Translation Bureau. Sub Roman numeral 2 now reads, members of the committee shall, within 5 days of the appearance of the Privy Council office, identify their preliminary lists of unilingual commission evidence or submissions for priority translation to the joint clerks, who in turn shall relay those requests to the Privy Council office, completely deleting sub C, sub B, 1B, sub C, deleting, sub D, deleting, and that's the end of the motion.
Désolé, mais c'est impossible de suivre, là.
That was impossible to follow.
C'est 2,000 $2,000.
Oui. Alors, M. Maloney, la parole est...
Mr. Maloney, the floor is yours.
Thanks, Chair. Look, we're running out of time here for this meeting. I'm okay with the amendments with the exception of paragraph little 2, where it says an order due issue, and at the beginning and at the end it says adoption of this order. I would suggest the wording be changed to a request be made at the beginning and at the end with, after the request be made instead of adoption of this order. And the provision about, I think because the next meeting is in 2 weeks' time, we don't want to lose that date. Why don't we agree as part of this that the first hour and a half will have the ministers and the second hour and a half will have the Privy Council and translation people come? So with those two amendments, I think we've got an agreement.
Perfect. So, Chair, we certainly agree to the next meeting, the 27th, having the ministers and Privy Council and the Translation Bureau, but not to change the wording of every request we've made from this committee, which is an order is issued. I'm sorry, that's not something that I'm willing to change at this stage. It's something we've done all along. It's the language we've used on every request we've made. That's the proper language. We're not requesting it. This committee has the power to order those things. They can refuse, then be in contempt, which the DOJ is already.
I don't want it to kill the whole thing here.
You can do a sub-amendment if you want, or just leave it as is. We agreed to the 27th, obviously, but...
I think we've got an agreement on everything except for that one point.
I'm not going to change my mind on it.
Well, neither am I, so... Yeah, so we can vote on that one provision if you want.
Do we have an agreement on everything else? Ms. Romanado?
Appear separately for at least 1 hour each. We have the PCO as well as the translation. So the goal here, based on the agreement right now, if we can, to have them both come together for an hour and a half. So next meeting, we would have an hour and a half with the two ministers, an hour and a half with the Privy Council and the translation. So just the way it's worded right now, it doesn't say that. So I just want to make sure it's clear to everybody what we're agreeing to.
We agreed.
In our conversations, that would be a 90-minute meeting with the ministers and a 90-minute meeting with the Privy Council and the Translation Bureau.
Right, but then the word separately has to be read.
Yeah.
Yeah, I would just suggest that we, to my original point, separate this point out and allow us to vote up and down and get to a place there, and then move on to adopt the motion as amended.
All right, then, let's vote on the amendment. Mr. Maloney's amendment, which is to change the word in order to issue and to turn that to request.
A vote yes means that you support the changing from order to request.
Right.
Right? And no means it stays the same as order.
Yeah.
Okay.
And just to be clear, Mr. Clerk, at the last word in the section says adoption of this order, it should say within 10 days of the request being made. Yeah, you changed both or none, yeah. Yeah, obviously.
OK.
We'd change it if it doesn't pass.
Ça va pour vous, Mme Burke? Pour le procès verbal, vous allez être correct, vous démêlez avec ça?
C'est lui qui fait le procès.
Ah oui?
Ça me va complètement.
OK, bon.
Inaudible.
Alors, bon, ben, allez.
Amendment of Mr. Maloney. The Honorable Gwen Boniface.
Agree.
L'Honorable Claude Carignan CP.
No.
The Honorable Peter Harder PC.
Yes.
The Honorable Larry Smith.
Yes.
Mr. Nakvi. Mr. Nakvi.
Yes.
Mr. Maloney.
Yes.
Madame Romanado.
Oui.
Mr. Brock.
No.
Mr. Motts.
No.
Mr. Fortin.
No.
Mr. Green.
Je vote contre la motion.
Winners gratify cookies.
Okay, and you have 6-5?
6-5.
Yeah. Des pour 6 contre 5.
Alors, 6 pour.
6, 4, 5 against. So Mr. Maloney's motion has been adopted. Is that all then? Have we finished for today?
Well, Chair, the word separately in the first paragraph is being removed. We discussed it and agreed upon it, but I don't know that we formalized that discussion.
Lequel mot? Which word? Quel?
Committee invite the following witnesses to appear, comma, separately, comma, for at least 1 hour. The word separately is to be removed. Mr. Motts agreed to that.
In my version it is.
Oh, okay, all right.
So we were going to vote on that then?
Well, Mr. Brock, sorry.
As amended.
As amended.
La motion, quelqu'un m'a vu.
We say as amended? Yeah.
The Honorable Gwen.
Unanimous?
Agreed.
He's shown unanimous.
Unanimous.
Okay.
Can I use my gavel? Meeting adjourned.